In a ruling delivered by a three-judge bench comprising Justice Olga Sewe, John Chigiti and Josephine Mongare, the High Court rejected a petition filed by Busia Senator Okiya Omtata, activist Eliud Matindi and Katiba Institute. Some of the issues raised by the petitioners were that the Housing Levy Act is unconstitutional, discriminative, it didn't undergo public participation, it offends devolution, infringes Article 43(1) of the Constitution, which guarantees the right to housing, and that it is double taxing Kenyans. However, in its ruling today, the court ruled that the act is constitutional and that there was adequate public participation.
Having acknowledged that the predominant issue is whether the provisions of the Affordable Housing Act are in conflict with the Constitution, it is our considered view that that doctrine of avoidance is inapplicable.
It cannot be denied from the foregoing that the public participation was conducted. As shown, the National Assembly and the Senate focused on very targeted and specific stakeholders. In particular, the petitioners. We note that the petitioners took issue with the fact that the public participation for an act that was intended to affect all Kenyans was only conducted in 19 counties.
On claims of discrimination, the court ruled that the levy does not unfairly burden Kenyans as alleged by the petitioners.
The levy and the fact that it has been set at 1.5 of the gross salary was an infringement of Article 40, Sub-Article 1 and 2 of the right to property. And we have cited Article 40, Sub-Article 1 and 2, which says protection of the right to property, subject to Article 65, every person has a right, either individually or in association with others, to acquire and own property.
On claims that the housing levy infringes Article 43(1) of the Constitution, which guarantees the right to housing, Justice Chigiti added that the purpose of the Act is to provide a legal framework for affordable housing programs, stating that Section 3 and 4 of the Act did not infringe Article 43(1) of the Constitution, which guarantees the right to housing. The court also noted that the National Assembly holds the authority to determine how taxes are calculated, imposed, and collected under Article 95 of the Constitution.
Having looked at the sections, we are of the view that the Act does not offend the principle of devolution because the Affordable Housing Board under Section 16 has representation both national and county government, from both national and county government.
On March 19th, President William Ruto signed into law the Affordable Housing Bill 2023, paving the way for reinstatement of the contentious housing levy deductions. The legislation ropes in workers in the informal sector to make sure the regulations are in agreement with the High Court's ruling that rendered it unconstitutional last year. Under the law, Kenyans will continue being deducted 1.5% of their gross monthly pay. Busara Naman, K24 TV.